Thank you, everyone, and welcome to one of our very first in the series for Women in Echo, and everyone is welcome. I see that we have a great crowd already present. We had almost 100 people sign up even before right now. It is my great honor and privilege to be the moderator for this topic, knowledge is power, understanding and negotiating physician contracts. As the speaker is my sister, Renu Thamman, who has been an employment attorney for the past 25 years and has amassed an immense knowledge around this. And this webinar has grown organically over years of conversation and years of her helping physicians all over in all different types of contract negotiations and situations, and even more recently amongst cardiologists. So without further ado, I would like to hand it over to Renu Thamman, and we'll get started.
Thank you so much. Happy to be here. Hi, everyone. Thank you for attending today. As my sister said, my name is Renu Thamman, and I'm an employment attorney, and I practice in Chicago, Illinois. So today I'm going to be discussing physician contracts, and I wholeheartedly believe this topic is a really important one because the percentage of hospital employed physicians has exploded in the last several years. And the trend is for doctors to be employees rather than working in private practice. And because of that, many, if not most physicians will sign an employment contract during their career. And it is crucial to fully understand what you are signing so you can negotiate effectively. So this is a little bit about me. Take a look if you want later on. As my sister said, I've been doing employment law for 25 years and do a lot of contract work with physicians. And I also handle discrimination cases and Equal Pay Act cases for physicians. So before you begin your job and get that contract, you are looking for a job. And you're looking to find the right position that's a good fit. So some things to keep in mind are to really know as best as you can your short-term and your long-term goals. And this can include things like financial goals, lifestyle goals, and practice setting. And you can imagine what those entail, but it's important to look at each and every one of those to see what is going to really work for you. So the key to finding a good fit is really trying to understand the culture of where you are going. And there's a lot of talk these days about workplace culture, and I think it is a really critical piece to look at before you start somewhere. And I just suggest that you do as much research as you can, and you do your due diligence. You do everything. You search the internet. You speak with support staff or other physicians in the group. Speak with anyone you may know practicing at the same hospital, even if they're in a different specialty. Find out the reputation of the group from others. Just seek out every morsel of knowledge. It will help you. And when you interview with a potential employer, you should ask a lot of questions. You should be interviewing them as well as them interviewing you to see if they are a good fit. You have worked really hard to get here, and it is not just about who can give you an offer and who's going to help you pay off your loans and pay the rent. You deserve to be more discerning for your own sake. So some key contract terms I wanted to discuss today that are generally in most employment contracts for physicians are the ones I've outlined here. So it's important to know the basics of what key terms you're looking at when you're reviewing your agreement. It's also important to look at any documents that are referenced within the agreement, such as an exhibit or a schedule. They all need to be reviewed. If there are any laws or other rules referenced, those also should be looked at. So I will go through these different provisions in the next slides, but this gives you a general overview of key contract terms that you should be looking at and aware of and highlighting as you go through your contract before you sign it. So the first one is term and termination. So for the duration, how long is your initial period? That often can be 1 year, and sometimes it's longer, 2 or 3 years. Does it automatically renew? And what are the start and end dates? And it's important to calendar those dates and know those dates. So it's very important that you review the termination clauses very carefully. So there will be 2 ways that a termination is outlined in an employment agreement. One will be termination for cause. And for physicians, those will be very egregious things such as criminal activity, loss or suspension of a license, failure to maintain privileges at a hospital, or a breach of a material term of the agreement. But cause can also be for more subjective things, such as a repeated inability to work with others in a professional manner. That is one I have seen in a physician's contract. So you should also look to see, is there a for cause provision for you? Meaning, can you terminate the contract if your employer does something that would constitute cause? So if there is one, and often there is not, and it's one-sided, if there is one, it most probably will be pretty short and limited, but you still need to know what it is because those are your rights. For example, a physician may have the right to terminate immediately if there is a breach of a material term of the contract and it hasn't been corrected by the employer within a certain time frame and you have given proper notice. And notice will be determined by the contract. There will be a specific provision within the contract that says you need to notify this person in this manner. So it may be certified mail, it may be email, but you have to follow that provision to give proper notice. So there can also be termination without cause. So that means that either party can separate, but there will be generally a time period for that. I've seen most often 90 days to 180 days where either party can terminate without stating a reason. But you still have to give written notice, and again, pay attention to exactly how that is done. And you should look at whether the notice is done consistently for both sides, meaning if you have to give 90 days, they also have to give you 90 days. So some other things to consider are, what are your duties going to be? And that can fall under, or there can be a lot of things that fall under that. So you should ask questions about any anticipated changes in duties or expansion of responsibilities. find out if that would come with additional compensation. You need to advocate for yourself, and especially women need to do that. And being aware of those kinds of things will help you do that. So you should know when your renewal period is coming up. That's why I said to calendar those things. And often there's an auto renewal. So you have a 1-year contract, and then if no one has said, we're terminating the agreement, then it just automatically renews for another 1-year period. So know when that is and know what your notice period is. So you talk to your employer about changes that you would like to be made. So duties obviously can encompass all of these things. What are your work hours going to be? What will your clinic responsibilities be? Will you be doing research? How much administrative work will you have? And is that separately compensated? Will you have call coverage? How many people are within the group who you rotate with? And what if that changes? How much support will you get in your role from administration? And again, as I talked about, trying to find out if there is an expansion of responsibilities, what's going to happen. So looking at compensation, there are a few common structures that we see in medicine. So one is a guaranteed salary, easy to understand, often limited to lure physicians into a particular job, I think. And it can be a good lure, and there's nothing wrong with that, but it's necessary to understand that may be for 1 year, 2 years, 3 years, however much you can negotiate. Another structure would be a percentage of received revenue, and a third would be revenue minus the costs and overhead expenses. And the last is looking at RVUs. So I'm sure you are all familiar with RVUs. I have learned a lot more about it working with physicians, and it does seem to be the most common structure being used, especially in large hospital settings. So the good thing is that there is some transparency here with RVUs in that they are standard and the conversion factor is standard, and those are things that can't be changed or edited. And you also get paid for the codes that are submitted, whether they are paid to your employer or not. But at the same time, you're only getting paid for what you are billing. So you should look to see if your contract discusses RVUs specifically, and if the terms appear fair and realistic. Unfortunately, the RVU system does create a lot of competition for physicians competing for patients. And I think the hospitals encourage that. But the physicians end up competing because they want to meet their minimum numbers. And those minimum numbers can sometimes be within your contract. So definitely something you need to pay attention to. So usually RVUs are just one part of the compensation package. And that is really important because things like mentoring younger doctors and handling matters outside of patient care are not included in RVUs. So one other thing to look at is look at your bonus structure. So there often will be a signing bonus, so you need to understand what that is. Obviously, you see the amount. I've seen in a lot of contracts that if you leave before a certain period of time, you have to pay back those signing bonuses. So that can be something you can try to negotiate out up front. Also, yearly bonuses would be part of the contract or the formula or something should be part of the contract. And that can be tied to productivity as well, but it can also be tied to administrative duties. Or sometimes administrative duties are paid by the hour. So those are all important things to look at and see what the definitions are for all the particular things. These are all separate things. So there would be, a sign-on bonus, and then looking at a yearly bonus, and then potentially also looking at administrative duties and if there's separate compensation for that. So understanding the specifics of all your benefits before you need them or use them, that's obviously very important. Now, some things will probably be pretty obvious, like the, X number of vacation days. But something to think about in conjunction with that is look at your CME days. Are those included in the vacation days, or are they separated out? They should be separated out, and there should be separate time for that, and there can often be paid CME up to a certain amount as well. So another thing to look at is severance or notice pay. So for instance, if you get a notice of termination without cause, and it is for a 60 or 90-day period, there should be a specific term saying that notice period is with pay. So relocation expenses should also be delineated in writing, as well as malpractice insurance, including tail coverage, meaning post-employment, who's paying for this. More and more employers are trying to put this burden on the employee, so it's very important to understand what that coverage is, and see if there is wiggle room there. Is it possible to split that cost with your employer? There may be things that they are willing to do if you discuss that with them prior to signing. And again, all of these things should be looked at and understood, and several of them may even have their own documents to look at. And I know it's a lot of reading and mumbo jumbo, but when you need that insurance, that disability insurance, the sick leave, you're going to be in a difficult place, and you want to know what your rights are, what you are entitled to up front. So several key pieces in an agreement, a physician agreement, are going to be confidentiality and non-solicitation provisions. Confidentiality agreements, this protects employer trade secrets from disclosure. So it would include things such as patient lists, financial statements, and internal memos. And confidentiality is pretty universal, and this is an obligation that will be ongoing. There's not going to be a limitation in time for confidentiality. Now, non-solicits, on the other hand, there will be a given time period for them, generally somewhere between 1 and 3 years. So there'll be two parts to the non-solicit. One will be a non-solicitation of patients, which will prohibit you from asking your patients to follow you to your new place of employment. You can't solicit them to come see you elsewhere. And the other part would be non-solicitation of employees, meaning You can't ask your colleagues or support staff to come join you at your new employer. And again, look at how long this lasts, because maybe after a year, you can bring on that perfect person you used to work with. So, okay. And non-compete agreements is my next slide. And this is a really critical piece of any physician contract. And this provision is all about protecting the employer's interests and not you, because it is putting a restriction on what you can do with your career in the future. So this is very critical, and you need to pay really careful attention to every word within that provision. So you need to look at a lot of different things. So I've outlined that they are legally enforceable in Illinois if they're reasonable in scope and duration. In Illinois, it has been upheld. 2 years of restrictions have been upheld as reasonable. Reasonableness will depend on looking at the geographic radius, and that's also going to differ depending on whether you are in an urban or rural area. So one other reason why these agreements are so important to understand is if you do breach a restrictive covenant, you could face legal liability that could include an injunction, meaning stopping you from doing what you are doing. Say you are at another job in violation of your non-compete from your former employer and you don't realize it, or you think no one's going to come after you, there can be an injunction to stop you from working at that job. There can also be other monetary damages and, of course, legal fees and costs incurred by your employer, often within that agreement, or if it's not within the non-compete agreement itself, clause, I should say, it will be somewhere in the employment agreement that, if they have to come after you, then you're going to be liable for their fees and costs. And that can be a lot of money. So one thing to pay attention to is there a distance in your non-compete? Meaning, can you compete if it's more than 5 miles away, your new job, that is, or 10 miles away, or 20 miles away? Where is it in relation to? So these days, a lot of physicians work for big hospital systems, and they might have locations that are spread out, and perhaps you are practicing at multiple locations. So again, where is that definition? Where is that radius stemming from? Is it from all locations? It shouldn't be. It should be from really where your primary practice is. And if you do practice at multiple places that are really spread out, that's something you need to look at as well. So another thing to pay attention to is how long is your non-compete agreement valid for? So 1 year is going to be better than 2 or 3. Employers generally put in 2 or 3, but I have seen someone negotiate it down to 1. It is possible. And again, reasonableness will vary depending on your location. Rural locations, which have fewer practices and that are further apart, it may be okay to have a larger geographic restriction there versus a densely populated city. So if you have any concerns or questions about this provision, you should have it reviewed by an attorney to see if it's fair and if it's based on the law of your state. I can tell you in Illinois that this year there were several changes made to non-competes within a state law called the Illinois Freedom to Work Act, which adds further protections for employees subject to non-competes. I actually helped work on this law, and we were really excited to get bipartisan support for this law because it helps clarify things for both sides. But some highlights include within Illinois that, for instance, you need to be given 14 days to review a non-compete or a non-solicit. I have seen a lot of people sign an agreement and have no idea what they have signed because they're expected to do it all in one day. They start a job, here's a whole binder of documents to sign, and it's difficult to know what you're actually signing. In Illinois, you also have to be advised in writing to consult with an attorney. And if those provisions are not followed, that agreement will be void. So there also needs to be valid consideration for a non-compete or a non-solicit. And that means something of value, which can mean 2 years of continued employment or other consideration, which would likely be additional compensation. The employer also has to have a legitimate business interest that needs protecting. So in the case of hospitals, that'll be something like patient information, protecting that patient information or protecting that patient population to keep that business. Another provision that seems to be in a lot of agreements, not only physician agreements in general, is mandatory arbitration. So this means that you cannot take your case to court, but you have to go through a private process that's governed by its own set of rules. These decisions are binding and they are not public. So unfortunately, it is hard, if not impossible, to negotiate this provision out, but it is still critical that you understand what your rights are and also what's being taken away from you. So certain cases, though, going forwards cannot be subject to mandatory arbitration, and there are people working to even broaden that further. But in March of this year, President Biden signed into law the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. So now someone bringing those particular claims can opt for court or arbitration. So they have a choice. They would not be subject to a mandatory arbitration provision. So when you are trying to negotiate some changes to your contract before signing, you may find it intimidating to do so, but I have seen many physicians successfully negotiate for themselves, and having some education will help you do that. So it's helpful to understand the different types of negotiation style so you can figure out what may work for you. So it always works best when you know the other side, and unfortunately you don't always know what the other side is like when it's a new employer, but you do your best. So one method would be collaboration, where you are using communication to your advantage. One would be accommodation, where you're maybe being a little subservient and making the other side feel like they are winning. And a third would be a compromising style, which makes your goal look like a compromise. And I'll highlight this one because it's probably the one I use most often. And when I advise physicians and others, it ends up being the most effective one because you can figure out what your priorities are so you can give on things that don't matter as much to you. And then, the other side will likely give on some things as well. So avoiding is using silence as your friend, meaning you're just not responding because you've put your offer out there, and if they don't want to respond, then you're willing to take those consequences. And similarly, competing is being unwavering. There just may be things that you don't want to give on. So a couple tips about negotiation. The most important thing is to be prepared. You have to plan, you have to research, you have to have good communication to get the best result for you and to start off your employment in a positive light where you feel empowered and that you are listened to. Documentation. I have a separate slide for this because it is really important that you capture all key terms in writing with specificity. Do not rely on oral promises. You need to review all the terms in your contract closely. Sometimes the headers are not accurate representations of the actual content. So that can be especially tricky when looking at things like non-competes and non-solicits. I've seen headers where it says non-solicit, but it really is a non-compete. If there are other documents that are referred to within the contract, make sure you review them. Make sure you ask for them because they may not give them to you up front. I mentioned notice period earlier on, and like I said, there will be a very specific way to give proper notice. So, for instance, if there's a notice of a breach of contract, there is a person to contact and exactly what method should be used. So everything is rosy and great when you start a new job, but contracts are there in case things go sour. So they're there to provide specificity and a clear understanding of your and your employer's obligations and recourse if something unanticipated happens. My last words of advice are read your agreement, all of it. As my favorite professor in law school said, keep reading. Or you can call my office or reach out to an attorney for assistance if you need help. Thank you.
Thank you so much, Renu. That was outstanding and very comprehensive. And I think we have time for some questions. I'll start with one just for clarification for myself. What is the difference between a non-solicit, as you were talking about, versus the other term, which was
non-compete?
Non-compete. So,
right. So they are very different. So a non-solicit, like I said, there's two types of non-solicitation. So it's really preventing you from soliciting business directly from, say, you have a set of patients and you can't say, come to me at my new practice, and this is where I'll be.
Right.
And you, the same, you cannot tell your favorite coworkers, come work for me or with me at my new place of employment. Whereas a non-compete is a total prohibition against working within a certain set of parameters. So that's going to be defined in a certain way within your contract, for instance, within 5 miles, within 10 miles, that kind of thing.
That's really interesting. And I think in this day and age of social media, and if you have, for example, you're a physician and you may have followers on different platforms, you might be announcing that, hey, I'm now working at a place down the street. And it's just interesting if a patient just follows you, you didn't solicit them, but they found out that you're,
Right.
working down the street or wherever. Is that enforced? I mean, are there any rules around that, or should one be careful not to put anything out on social media if that's the case?
Possibly. So again, it's going to depend on the specific language in your contract. So I have seen non-solicits where it says you cannot solicit directly or indirectly. So in that case, I would advise you don't put that out on Twitter or social media, because that could be an indirect method. So, but for those patients who love, that certain physician, they'll find you. But again, it all comes back to the specific language of your contract.
Yeah. So we have another question that's come up. Do you have an opinion regarding online contract review services such as resolve.com?
I don't know all the options out there, but I just know in the legal world when, for instance, there are websites that will do forms, you'll see legal in a box or legal Zoom. It's going to be very generic, and I don't know what kind of service you're going to get or what kind of background the people advising you would have. I just think it's important to, if you are going to use any kind of legal services, that that person's background, that they are an employment attorney, that they are familiar with these types of contracts, so you get the best advice you can get.
When you or if you have any wiggle room in your negotiations, have you seen people be able to sort of change their RVU targets within contracts successfully, or is that just so rare?
I have not seen that, but I would say it's not impossible, because you do need to look at, are they being realistic in their expectations? And when you first start a job, you may not have a lot of patience, and that kind of ties in too to those guaranteed salaries and how long is that going to last, because you need time to build up your patient population and kind of get those numbers up. So
Yeah.
the longer you can have a guaranteed salary of a certain amount, the better. Or to have a guaranteed salary, or the option of having it paid, based on productivity, depending on which is better. So I've seen that as well.
Yeah. I've seen people, in academics they have certain RVU targets, and so if they don't get a pay raise, they may ask for RVUs to be reduced, so that they don't have to meet those. So it's sort of another way to ask for money, but not directly. We have another question. Another question that's come up. How important is it to have a contract reviewed by an attorney in the state in which you're looking to be employed versus out of state or someone farther away that you may trust?
It depends. Again, so I think having that trust is really important, and probably that person you trust will give you the right advice. They will tell you if they can help you or not. Again, I think the number one thing is having someone with employment experience and experience in looking at physician contracts. I do know several people who will look at contracts from different states all over the US. I have looked at contracts from other states. Certain things are just kind of universal, and lawyers do have the ability to make sure that they are checking on any nuances that may be different from state to state, such as non-competes, language may be, or regulations may be different from state to state, and I'm sure other things as well. So sorry, not a very clear answer, but yeah, you should definitely start out talking to that person that you trust, and then make sure you're getting advice from someone with experience.
So the answer is both. You need both, maybe.
Yeah.
So if you get if you, within your non-compete provision,
Mhm.
have a distance that is ascribed to it, how is that distance actually measured, and is it enforceable? Like, how does that work?
It is enforceable. I mean, I tell clients to look on something like Google Maps, and we're going to look at all the different ways you can drive and what all the distances are. So look at all the different scenarios for what that is. So.
And then like if you start in a hospital system, and like most across the US, they're like Pac-Man, and they keep buying all the hospitals, around in the area. And how would they, and for example, if you moved hospital, if they put you in and said, okay, now you've got to cover this other hospital, is that distance going to be defined from the new place that you are now working at, or?
So it again will depend on how the contract is worded on that issue. So ideally, that will be very carefully crafted, and you may want to try to add some language in there. I've seen it where the distance would be measured from the place that you do your primary practice, or maybe where you do 50% or more of your work. So there's different ways of narrowing the issue. So, you want to make sure it's as specific and protective as possible, and anticipate for those types of things, because you're right. I like the Pac-Man analogy. We're seeing that happen all the time.
Yeah. Okay, we have another question. Do employers have a right to make changes to a contract before the terms of the contract are over? For example, changing RVU targets in the middle of your contract.
So that's going to depend on whether how your RVUs are spelled out in the contract, and also there's generally a provision within contracts that say any modifications, need to be made in writing. So, I assume, well, don't assume, but it should be in writing if there is some change. And there may be some vague language within the description of RVU saying, we retain the right to make changes as necessary. So there can be some open-ended wiggle room for an employer. So it's good to, look at that.
Mhm.
And it somewhat goes back to the culture of where you are working. Like, are they really going to mess with you in a really significant way? Hopefully not, but it could happen. And knowing the culture can help with that kind of thing, but you should read and see what the specifics are about RVUs, and also how the contract can be modified.
So you mentioned in your talk trying to gain as much, knowledge is power, trying to gain information before you sign the contract about the place of where you're going to work. And we can always go to Mr. Google, and
You can
uh,
find out more than you think,
yeah,
um, sometimes.
are there sites that besides Mr. Google, or places, for example, if I want to know for an administrative role, how much is like average? What should I ask for? They're going to make me director of the Echo Lab, and so or give me some title. What is that really worth in that market? Is there a way to find out? And that goes for sonographers as well. Like, how would you?
I I am not sure exactly how you would get those numbers, but one thing would be to, again, talk to as many people as you can. And it's so important to have a great network of people. And that's where you're really going to get the best information, like physician to physician. Um, what have they been able to do? And so what should you be aiming for as well? And, I think people are trying also to fight for more transparency and pay and all of that, because traditionally it's hurt women so much, and minorities. So I think we're seeing some changes to that kind of like pay transparency. So I know in Illinois there is more transparency required now. So that could help in the future for physicians as well.
Yeah. I would love for every state to sort of adopt what they've done in New York. I believe that they have to write the range if an employer is asking or describing a job that they have to put a pay scale or something there, and so that becomes public. We've tried through social media to get people to divulge how much, not on social media, but solicit them through social media, and it's been very poor response. I think there's a lot of secrecy around that, and that I don't know when that's going to change, but I'm glad you're fighting for those kind of equal pay um, laws, and we're all hoping that we'll get there someday. But if you're in a salary, they offer you a number you really don't like, what are some ways that you can sort of a roundabout way, end up getting a little bit more, but not getting like more dollar, but through the other terms? Anything else that you should be thinking about?
Yeah, and that's why earlier I was just talking about you need to know what your goals are, short term, long term, and make your list of your priorities. Is it pay, and that's what you want to fight for? Saying, this other physicians in this specialty in this area are getting paid a lot more, and you know you assume by this point, if they're offering you a job, they want you, they've gone through, a lot as well to narrow their choices down and to pick you. So, um, you should use that and to your advantage. So pay is just one piece of the puzzle. There can be so many things. There can be hours, there can be call schedule, there can be, not wanting to do administrative duties. I don't know if anyone can get out of that anymore, but
Yeah.
a lot of things to consider and to really have that talk with yourself to understand what your
Yeah.
real priorities are, because there are so many things besides pay.
Yeah. Interestingly, there's a Kathy Biga, who's the CEO of a big corporation in Illinois, and she of physician practices, and she's the incoming president of the ACC. Said they have negotiated for scribes and people, nurse practitioners, for example, to take call, to sort of spread that burden. And that also helps not only retain their physicians, but get their physicians and then keep them from burning out. And that applies to physicians and also the sonographers. And so I think that's maybe another thing people can keep in mind, like ask. I mean, the worst they can say no, but
Yes, I
right.
think that's really important to keep in mind. Again, they want you because they're offering you the job, and you should feel that value and use that value to get the things that you need. So
Is there also a way you think one should practice? Because, it can be very intimidating to go and say, talk one-on-one with someone who's got that holds potential, holds the power over you. Do you practice and recommend practicing on your family and friends, how you would answer a question or how to ask for something?
I've had physicians sometimes they prefer to do it in writing, so that's one option. So I have, for instance, drafted some potential changes to a contract, and then I'll draft the language, but then share it with the physician, who then uses that in their own kind of verbiage and to negotiate some changes. So that can be one way, because you really you've thought it out for much longer, maybe even had an attorney behind the scenes, because sometimes you may not want an attorney talking to your new employer because of many reasons that probably are very obvious, but no harm in having someone behind the scenes. So
that's a great point. And I think that's one that all of our people on the webinar should keep in mind, that there are other ways to get to the point you want to be at. So in the interest of time, we have 1 minute before 8:00. I wanted to take this time to thank you, Renu, for being our guest speaker and teaching us so much about a very essential part of our lives, contracts. We really appreciate your expertise and willingness to share your knowledge with us. And I appreciate everyone who's asked questions and been on this webinar. It's obviously being recorded, and it will be here for anyone who wants to, again, review and let your friends know if they want to, look at this webinar down the road. And so thank you to all of you, and look forward to seeing you all again on our next webinar in 2023. Thank you.